In other words, the panel said Trump wins, but the court hasn't issued the final order saying Trump wins. So now the government is subject to an injunction that the panel said is wrong. It's erroneous. So if the president impounds the funds because Congress is spending them in a way that disables the president from following his constitutional duty, which is to take care, then it's unconstitutional. Nor does it specify what happens if the funds expire while Congress is considering a proposal. Okay, so there's not a lot of details on here. So Trump can wait till the end of the fiscal year and just say, we're going to spend a bunch of money on these things now. Major appeal in the Supreme Court of the United States. This one's fresh out of the oven, and you can see it's being delivered by D. John Sauer over to the Supreme Court of the United States. This is in the case against the AIDS doctors, okay, who we've made a lot of fun of here because we don't really know what they do. An AIDS vaccine advocacy coalition, aka the AIDS doctors, who just gobble up USAID money and then go chop off genitals in the sub-Sahara. So what's happening now is the DOJ is suing, and they're not happy about what's going on. They're going up to the Supreme Court, filing a petition for a writ of cert. So they're not actually suing, they're being sued by these people. But in response to what's been happening at the lower levels, they are knocking on the door, asking John Roberts to do something. John, here's where they start. This case began as an emergency over whether the district court had jurisdiction to order the government, the lower level judge, whether he could order the government to pay $2 billion, that's a lot of money, for contractual work completed under foreign aid grants, right? Pay them their money. $2 billion, that's a lot. I know we throw around like trillions and hundreds of billions. It's a lot. That goes right into the Democratic infrastructure. So Trump rescinded it. Now the lower courts are battling over it. Now that the district court at the lower level has installed itself as supervisor in chief for further spending and rescission proposals, they issued a preliminary injunction. They ordered us to make available for obligation tens of billions of dollars, not just the two, and spend many billions of dollars before September 30th, before these appropriations expire, right? The courts are saying, shell out that cash. Instead of seeking emergency relief in March, the government proposed a schedule. They said, well, how about we just appeal this stuff and we can duke it out up there? On August 13th, the DC Circuit panel, so the Court of Appeals, they agreed that the preliminary injunction should be vacated in its entirety, okay? So boom, Trump wins. The injunction is an order. You are ordered to pay the money. Court says, ridiculous, all right? DC Circuit panel, no, it's vacated. But then the full court, the en banc court, the rest of the judges, without even granting review, they have refused to either stay the injunction or to issue the mandate, okay? So in other words, the panel said Trump wins, but the court hasn't issued the final order saying Trump wins. So now the government is subject to an injunction that the panel said is wrong. It's erroneous. So the government then is now, we got to come to you. We got to ask you, Supreme Court, to give effect to the DC Circuit's decision, because they're not telling the lower judge, which correctly held that private parties cannot enlist Article 3 courts to supplant interbranch dialogue about the spending of money, okay? Which is a very highly engineered sentence. Well done. So in other words, these AIDS doctors don't have the right and sue in the Article 3 courts, in these district courts, claiming due process violations, violations of the APA. Our rights are being taken from us. Your right to billions of dollars of taxpayer money, you think you have a right to that or something like that? They do. They say you can't do that. There's already mechanisms for this. You got your grants terminated, happens all the time. You can file over here. You got lost your job as a federal employee? Okay, go file over there. It says, since the founding, Congress and the presidents, this is Trump writing, and the DOJ, have occasionally clashed over the use of appropriated funds. And this is a big issue, some good history here, because we always have this conflict between the two branches. The legislative branch, Congress, they have the power of the purse, so they appropriate the money. The president executes the law. So then he takes that money and he does something with it. Now, the thesis from the original interpretation is that you've got these two balancing interests. Like there's a natural tension between there. Congress says, we think that this is necessary and proper, which is their obligation under the Constitution. But the executive has the take care clause. Okay, so they can be against each other. If the Congress passes money that is illegitimate, we order you to go do this illegitimate thing, and it's unconstitutional, the president's not obligated to do that. It's a separate division of power, and there should be a tension. And if the president doesn't spend the money, well, that's okay. And Congress is very upset about it. They still have powers. They can go impeach him and remove him. It's not complicated. There's a check on that power. So if the president impounds the funds because Congress is spending them in a way that disables the president from following his constitutional duty, which is to take care, then it's unconstitutional, right? We want the impoundment process to be enabled so that there can be this tension and they can work it out through the political process. So some history on this. Congress, with the power of the purse, appropriates money for specific programs. Now, the president has the exclusive authority to enforce the laws, has often disagreed about how those funds should be spent. A lot of history. Rewind the clock back to President Thomas Jefferson, number 3 in the House. He famously withheld $50,000, a lot back then, for gunboats on the Mississippi during negotiations over the Louisiana Purchase. And Lyndon Johnson, remember him? He impounded funds for small watershed projects for the construction of a national aquarium. I'm like, well, okay, it's an aquarium, so what? Like, nobody cares about that. But this has been a historical battle, okay? The executive doesn't want to spend the money that Congress appropriates. They have long resolved these disagreements, though, through the political process. For instance, when President Ulysses Grant informed Congress that he would not spend funds appropriated for harbor and river improvements based on his view of the national interest, members of Congress objected. They said, what? We just passed it. You got to honor this. But Congress ultimately dropped the issue. Wasn't that big? And no efforts were made to restrict presidential discretion over the appropriated money back then. Now, for most of the nation's history, this give and take involved informal interbranch negotiations as it was structured. But then our country, as part of his perversion, a lot of it happened in the 70s, Congress went mad. We have these like waves of insanity, like the 1913s, the 1970s, and Congress came out. Nixon was impounding a bunch of money. He's like, nope, I'm not spending that. Are you kidding me? No. And Congress then responded. They passed this Impoundment Control Act, which codified mechanisms for the political branches to work through these disputes. If there's a problem, this is how you handle it. Now, under the act, the executive branch, so Trump here, would initiate the negotiations. If they say, okay, Congress, we know that you said that we have to spend this money, but we're not going to do it, got to notify Congress. Then Congress can rescind the money if they want, citing the code. Now, the ICA, the Impoundment Act, does not set any deadline within a fiscal year by which the executive branch must propose rescissions, nor does it specify what happens if the funds expire while Congress is considering a proposal. Okay, so there's not a lot of details on here. So Trump can wait till the end of the fiscal year and just say, we're going to spend a bunch of money on these things now. Presidents have proposed rescissions shortly before the end of the fiscal year, and funds have not been spent when Congress failed to act on proposed rescissions before the funding lapse. Now, the ICA involves the judiciary in those interbranch disputes only as a last resort. Okay, don't get the courts involved. It authorizes suits to challenge the non-compliance, but the act contemplates which such suits only if the comptroller concludes that the executive branch failed. All right, so in other words, these people shouldn't even be here. This is a lawsuit that should be brought by the comptroller general. They don't have jurisdiction to just sue over this because the law says that guy makes the claim. If the comptroller concludes that the president failed to make the funds available, then they can come up with that conclusion and authorize a suit. But even then, Congress only authorized this person. They can sue the executive branch only after notifying Congress of the proposed suit and its rationale and 25 calendar days of a continuous session in Congress to elapse. And so they can't just sue out of nowhere. There's all these hurdles because it's a ridiculous public policy, by the way. You get to sue the government because they're not giving you money that you think, and we want our courts to enable that. No, we've got a whole other set of systems that are built for that. This isn't like Congress is the appropriate counterparty to the executive branch. It's not the AIDS doctors when it comes to government policy. Regardless of whether such suits should be justiciable, whether we should allow them to proceed in court, they make plain that Congress intended to strictly limit federal courts' involvement in these disputes. But in March 2025, Trump comes in, he's sworn in, a single district court supplanted that entire process. The court said, notwithstanding what the law says, they said basically anyone who might get appropriated funds but fears that they can be impounded can sue. They can sue preemptively to challenge the impoundments. Under what basis? Now, as relief, the court further held that those private parties can obtain injunctions, and they got one. The district court thus displaced the process that the law says the political branches have to engage in to resolve these disputes. Private parties could leapfrog the entire law with new causes of action, and district courts could then be the appropriators of the money, right? They're the ones who then say, well, okay, you have to pay that. So they're basically the stewards, like the trustee of the money. That's not their purview. Now, thus here, the respondents, the organizations that intended to compete for that money, they objected, right? So all these AIDS doctors and everybody, that's our money, we need it. The district court in March granted an injunction, said you have to pay them $12 billion. The government got an appeal. We're working our way up. Now we're at the Supreme Court. Now the DC Circuit vacated it, so you can't force them to pay anything. But then now with the deadline, the en banc DC Circuit has effectively maintained the preliminary injunction, notwithstanding the panel opinion issued after full briefing and argument, and exacerbated all the consequences. Now, absent this court's intervention, the DC Circuit is not acting, and it's going to preclude the government from proposing rescissions and allow the funds to expire by September 30th because we're stalled out. In other words, it will effectively force the government to rapidly obligate some $12 billion of money, overriding Trump's foreign policy judgment, and that's our elected leader, right? So much for democracy from these judges. That alone is irreparable harm, says Trump's DOJ. And unless this court, John Roberts, grants relief by September 2nd, which is coming up soon, the executive branch must also take, and this is why the court is stalling it out, they're like, well, they got a deadline coming up, and if they can't get it done, then they'll just have to follow our order. Must take extensive steps that themselves inflict irreparable harm. Now they're trying to negotiate with foreign countries about assistance. And even if we win, backtracking on those commitments, now we have to go say, okay, our court ordered us to give a foreign government a bunch of American money, but we won, and so now we have to go back to you, Uganda, and take a bunch of money back. We're still, by recognizing a novel cause of action for private parties to preemptively challenge these impoundments, so in other words, the private AIDS doctors can just sue the government because they're not getting money, the district court issued a blueprint for virtually any recipient of federal funds to circumvent the actual law and just sue directly. Regardless of when those funds expire, Congress never intended for the courts to superintend the disbursement of the money. And so that result would be alarming. And even under the injunction, they have no guarantee of getting a penny, making it more incongruous for them to effectively commandeer the spending of millions of dollars. And so we want to stay, and the government respectfully requests relief as soon as possible, but Supreme Court no later than September 2nd, 2025. They say you should stop the lower level judge. And the Solicitor General respectfully requests also an administrative stay of the order as well. Respectfully submitted by the Trump DOJ, D. John Sauer. And so we'll see what the Supreme Court does. We know that they're on shadow docket status, but we've got like 5 days or however many days are left in order for them to come in here and stop that money from going out the door because lower level judges think that other countries should have an AIDS doctors and the Global Health Council. And we looked them up. We went to their websites. Nobody knows what they do, okay? Is there an AIDS vaccine? You just take it and you're vaccinated against AIDS? I didn't think so. So what are they doing? They're advocating for it, and they have a coalition. So it's like they write blog posts or something like that, and they need billions of dollars to do it. Well, we got a new president, we got a new Congress, and we have a difference of opinion about what is taking care of America from the purview of the executive branch. And Trump won, the people voted accordingly, and now the Supreme Court should do something about it. So hopefully John Roberts and Amy Coney Barrett get this and act with haste.